Well, Justice McLachlin, Beverley, thank you very much for joining us and welcome to Salt Spring. Though, of course, you're not on Salt Spring, you're in rural Quebec. So we meet as, appropriately for Halloween, we meet as ghosts on the internet and so on. So.
Nothing's real anymore. I wish I were on Salt Spring. I know it's such a beautiful place and I have never visited it. So I was really looking forward to coming and joining you last May, but we'll have to postpone that.
We will have to do that for sure. That would be great. As you know, a number of our forum members and people in our community have submitted some questions for me to ask you. But first, I get to talk about a few things that I've been wanting to talk to you about. And I think perhaps the best place to start might be a lot of our members know you as, particularly as somebody who has been very involved throughout your career with issues relating to women, with fairness and justice and equity, everything ranging from abortion rights and redefinition of violence against women and so on, to things like pay equity, access within your legal profession for women and so on. And when I was reading your book, which, by the way, this is probably a good point to show people that this is Beverley's book, Truth Be Told, and it's a wonderful, wonderful memoir of her entire life, particularly as it relates to her work as in the legal professions. At one point in the book, you in a somewhat summary way, you talk about what your work with women's issues has amounted to, and you say, "We are making progress, but half a century after I started my legal career, and 4 decades into the fight for pay equity, the most recent statistics show that women still lag behind men, earning just 87 cents on the dollar in 2015. And I've been thinking about this and thinking how to respond to the 87 cents on the dollar, which presumably is a whole lot better than it used to be, but is still 13 cents less than what it ought to be. And so the question in my mind is, how do we think about progress? And as I was thinking about this, 2 weeks ago on the news, there was the news that the Supreme Court had ruled in a case brought before it by 3 female members of the RCMP, who for many years have been fighting with the force for equity in their pension plans. My first thought was, why are they having to take this matter to the Supreme Court? Surely the question of equity in pensions, it should be something that we have decided a very long time ago. Rosalie Abella in 1982, I believe it was, had headed up a royal commission into, what was it called now? Royal Commission on, I can't remember exactly.
It was about pay equity.
Pay equity.
Equal pay for work.
And I'm thinking 1982 is 38 years ago now? 37, 38 years ago.
Time. Yeah,
so why, after all this time, have we not fully achieved fairness for women in employment and so on? Particularly since the actual judgment, the reasons for it for this particular case 2 weeks ago were actually written by Rosalie Abella. And I'm wondering what she thinks that, 38 years afterwards, she's still having to rule on the same issues. What is the nature of the progress that we've made, and should we be satisfied with that?
Well, we've made a lot of progress. It used to be a lot lower. Women earned a lot less, and we brought it up somewhat. But we need to make more progress. And the big problem, as is evidenced in the reasons, because there were dissenting reasons in the case you just referred to, is that the law has not consistently taken into effect the situation of women. Now, what happened in this RCMP case is that the women members, when they had issues with childcare or, I don't know, pregnancy, whatever, anyway, they, because of issues related to their family and their children, were working part-time. And that gave them, or as contractual, whatever, that gave them a salary. It gave them more flexibility, but it did not give them pension rights. So the essence of the claim is that because they were part-time because of a personal characteristic, the fact that they were women and had responsibility for their children, pregnancy, things like that, they were being discriminated against on the basis that they were women. And that is that is wrong according to the Supreme Court jurisprudence, which I participated in and which Justice Abella reiterated in this latest case. We have the Supreme Court, I still call it we, although I'm not there, articulated back in 80s through Justice McIntyre, Justice from British Columbia, the idea of substantive equality. There's two ways to look at equality: equal opportunity or substantive equality. Substantive equality takes into account the fact that a person is suffering from a detriment because of a personal characteristic they can't change, like being a woman, mother, whatever. And it says, we're going to make that up. We're not going to hold that against you. Formal equality or equality of opportunity says, well, these women got treated exactly like the men, and therefore they have nothing to complain about. So I'm very proud of the Supreme Court's work in developing substantive equality, and yet you still see the RCMP in this day and age, and the government fighting this to the highest court, and which is a little disappointing, I think, personally. I think the court majority got it right. I do respect the right of the other judges to dissent, but they said in essence, well, this isn't, this is because they were part-time workers. It isn't because they're women. And therefore they found a disconnect between the gender characterization and the detriment. But if you look at things that way, you never make progress, in my respectful opinion, because you keep disadvantaging an already disadvantaged group. And why are you doing it? If you really look at the matter holistically, you're doing it on the ground that by ignoring the fact that these are women who made these choices because of their gender and matters associated with their gender, such as being a mother. So this is a difficult area of the law. And as you can already appreciate from my answer, equality jurisprudence is complicated and different people come at it different ways. But I do hope that in the future, our substantive conception will be upheld. And Canada's a leader in this. The late Ruth Bader Ginsburg was approaching it in some of her decisions. She said people should never be disadvantaged because of a personal characteristic that they can't change. And when that happens, the law should look at it and say, we're going to try to find ways to compensate so that you are indeed treated equally. Mm-hmm. So in the end, these women did get their pension, but you can understand their grievance. They worked. They couldn't work full time because of their situation, but there they were without a pension at the end of the day.
The final bit in the report that I read about this says that Justice Abella said that it will be up to government officials to come up with a plan to allow full-time members, et cetera, to receive pension credit. So has it been, the actual effect for these women been passed on to government to implement somehow?
Well, the government will have a duty to bring the law into compliance with the reasons, the majority reasons. So
Right.
we can expect the government to act on that, and it may. I would expect, I don't know this, but one would hope that their pension will be retroactively reinstated.
This leads me to one of the questions that was submitted by one of our members. Unfortunately, I seem to have forgotten to write down the name, so I apologize for that. But here is the question. It's on a similar issue, but relating to Aboriginal rights. And it says, on the matter of Aboriginal rights, we see the Supreme Court of Canada decisions not being implemented by the Crown, giving rise to serious problems decades later. Is leaving the details to subsequent negotiations proving to be the wrong approach? Does it leave us stuck in a cycle of conflict, litigation, and further conflict? Or does the court have to stay at a certain level of generality to maintain a separation of judicial and legislative functions? I guess what he's asking is, can the court do more than, in a sense, leave it in the hands of government to actually fix the problem?
Well, a good example is the court. The court can declare the rights, and but often the implementation of those rights is very complicated. A good example is the Marshall case in Nova Scotia, which has recently been in the news because it was many years ago. But the majority of the Supreme Court said that pursuant to a certain treaty that had been made in the 1600s, the Mi'kmaq people in Nova Scotia had the right to earn a fair livelihood from the fishery. The treaty said that they had the right to trading houses. It was clear that the Indians were, as they were called at the time, were very interested in trading, and they made peace with the English, who had been at war with the French. They had been siding with the French on the basis that they would continue to have their trading houses. And the majority of the court, I actually dissented on the historic thing, but the majority of the court held that the modern day version of the trading house was where they would trade furs and so on, was the right to a moderate livelihood. And so the court declared that, and then the court said it would be up to the federal government to implement a scheme so that they would be able to, the Indigenous people would be able to have a fair share up to the point of a moderate livelihood. Well, this has proved extremely difficult, as we know from recent events. And we have heard calls from the Indigenous people saying, you've had 20 years or whatever it was, almost, it's not quite that long, to come up with a scheme so we can share this equitably, and you still haven't done it. So finally, the Indigenous people started setting up their own things and so on. Anyway, all that to say, there's no way a court could get into that amount of detail about who gets to fish where, when, or the lobster fishery changes or moves around a lot. That has to be left to government regulation. And so that's where we are. In British Columbia, for the most part, there were no treaties. And so the court's jurisprudence declared the right to practices such as fishing, and also the right to title in Indigenous title in lands that had been traditionally used by the Indigenous people, where they can prove it. But it's a complicated thing to prove it. Sometimes more than one Indigenous group is claiming the same land, and that has to be sorted out. Sometimes there are questions about the boundaries or the continuous use in prehistoric times. This is a very complicated thing. So it takes time. Now, that doesn't say it should take as much time as it has, because I think both the Indigenous people and the governments would concede that it's taken too much time. It should be expedited. It should move more quickly. All this to say, the courts often can't go further, but we need to, in my respectful opinion, try to speed up the processes whereby we put these, the regulatory schemes, the grants of title, whatever it may be, whereby we put this into practice.
Mm-hmm. That last comment leads me to another question that came from Michael Clark here on Salt Spring Island. He's speaking generally about the court system, and his question is, our legal system is clogged with cases that all seem to take far too long for resolution. Justice is not being seen to be done. What's the problem and how can it be fixed?
Oh, wonderful question. I started asking this question about around 2005 when I was Chief Justice, and because I could see that people weren't getting access to the justice system. The law gives people certain benefits, rights, etc. in every area of life, and people just weren't able to realize those because they couldn't get access to the courts. And this is not right. Justice shouldn't be some sort of abstract principle. It shouldn't be there just for the well-heeled and corporations and that kind of thing. It ought to be there for ordinary Canadians. And so I started talking about it, and we got a lot of attention and a lot of impetus, and a lot has been done. And unfortunately, not enough, but a lot done on the ground to help people, often poor people and disadvantaged people, get some sort of justice out of the system. In the court system itself, backlogs are a perennial problem. And what is really worrying me now is that the pandemic is making that worse, because you cannot operate the courts in the usual way. There are many courtrooms are idle because people just can't come and present their cases and judges and be there safely. And those that are operating are usually dealing with very urgent things. So what was already a problematic backlog in many of our courts across the country, particularly trial courts, will be, when we finally emerge from this, a huge problem. And so what I'm saying, and I'm still involved in this area of access to justice. I chair the National Action Committee. I do many other things. But I think that we have many discussions about what's going to happen. Where are we going with this? How can we fix it? And a lot of the thinking is that we have to rethink how we deliver justice services in a fundamental way. Basically, we do it, and this is my view anyway, we do it in a 19th century way practically. Papers are filed, people come before judges. Our procedures in the court have not changed very much in a century, more than a century. And what we're living in a fast-paced 21st century digital world. And we have to adapt our justice system to the real world. And we're finding the good thing is that we're learning through the pandemic that a lot of things can be done virtually or by telephone, and you can have e-filing, that is electronic filing of documents. You can do all these things, and you can benefit from efficiencies in scheduling, for example, by using algorithms and this kind of thing to help you. And so I don't think that technology alone is going to be the solution, but I think I hope we will be seeing a lot of thinking. And I know your Attorney General in British Columbia has been consulting. I was on a committee where he was consulting what should be done to kind of rethink the way we deliver justice to people and rethink the system. Of course, it's always difficult because the legal system is inherently conservative. And lawyers and judges are proud of it. And they think what's worked in the past, we have to be careful not to change it too rapidly. But I believe that we can keep the good things. We can keep our jury trials. We can keep in-person hearings where they're necessary. But we can improve the efficiency by doing the things I've mentioned. And there's a final piece, which is I believe we have to put a whole new piece into our courthouses, our justice centers, and that is an upfront piece where citizens walk in and they're not confronted by a bewildering array of choices, systems they don't understand. There are people there to help them. What is your problem? Okay, you want a divorce. What is the situation? This is where you need to go. This is what you can do. We'll help you through it. If you don't have big issues, we can get it done for you very simply with paper orders, and it'll be all done. You don't have to go to lawyers or anything. That upfront piece, they're talking a lot about it in England. I think we're going to have to talk about it in Canada and build it right into our justice system.
It's very interesting that there's, as far as I know, there seems to be very similar thinking about things in the medical profession, partly with the huge backlog of routine things like hip replacements and so on, and they're wondering what they're going to do to address that, and then that's creating all kinds of thinking about alternative ways of delivering medical care. That's very interesting that that's happening. Yeah. I'd like to, if you don't mind, go to another thing which I read in your book. There are two passages that I'd like to put side by side because I think they're very interesting. At one point, when you first entered the Supreme Court, and you're talking a little bit about perspectives you're gaining on the practice of law at that level, you say, among other things, society should accord individuals maximum liberty, I believed, limited only by the imperative that one person's liberty should not infringe another's. And then a few pages prior to that, you quote Section 1 of the Canadian Charter of Rights and Freedoms, which says, "The Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society." I look at those two statements and I think, well, these are consistent. These are different ways of essentially saying the same thing, except in a way they're not entirely. They seem to rest on two somewhat different visions of human society. The first one reckons that we are all individuals surrounded by other individuals, and so long as we kind of don't breathe on each other's necks and leave each other alone, and if we keep 2 meters distance among ourselves, to use the modern metaphor, that is the ideal. The other one, though, by speaking of living in a free and democratic society, implies and suggests that human beings are not simply individuals, they are members of a group, they're members of society. And what we need to aim to do is not just to leave each other alone and not impinge on each other, but in fact to work collectively and make compromises and do things. So I was thinking about this, and I think this is ultimately not just a philosophical distinction, but quite topical at the moment. Particularly in the United States, for example, where significant segments of society are very animated about such things as having to wear masks because of COVID-19, having to keep their distance from each other and do a number of those things that are recommended. And they complain that this somehow infringes on their liberty. To wear a mask is almost a kind of, in rhetoric of some of them, a kind of satanic infringement of their basic human rights of liberty. And then when I was thinking of that, I came across a couple of days ago a report in The Guardian of former Supreme Court Justice in the United Kingdom, Jonathan Sumption, who, in giving giving an annual law lecture, said the British state exercised coercive powers over its citizens. The ease with which people could be terrorized into surrendering basic freedoms which are fundamental to our existence came as a shock to me in March 2020. The emergency measures were the most significant interference with personal freedom in the history of our country. And you think, whoa, that's a pretty extreme but very articulate statement of that libertarian view that we are all individuals, and any effort for us to work collectively is somehow an infringement. I know that the two statements that I read are consistent, but they don't seem to be. Can you talk a little bit about that distinction?
Oh, I'm glad you caught me out there. But right, the first one, it certainly has a libertarian tone, but it can be seen as consistent with the second one, the second articulation, which I think is a fuller and complete explanation. Depending on how you interpret liberty, you can argue that the person who refuses to wear a face mask at a public gathering where you cannot social distance is infringing the other person's liberty, the right to life, liberty, and security by putting their security at issue. So in that way, you can philosophically reconcile the libertarian. But I understand your question is very, very good. There are two ways of looking at limiting rights. All rights have to be limited, but one, the libertarian Jeremy Bentham way is to say, I can do whatever I want as long as I'm not preventing other people from doing what they want. And that is the libertarian view, and that is what you're seeing in the people who, like Justice Sumption, whom I know, and he is a wonderfully intelligent person, but obviously he's a libertarian, he's a Benthamite. And in Canada, though, we really don't have a choice, because our Constitution, as it has been interpreted by the court, allows for rights to be limited, provided the state can justify this as a reasonable limit in a free and democratic society. And the way that's been interpreted is that to be a reasonable limit, reasonable limits are what is reasonable is much broader than the narrow civil libertarian view. It allows for collective action to make improvements in society, to keep people safe, to make the society a better place. And so the way our charter works is that the first step of someone who has a charter claim is that they show that a right they enjoy is limited. Perhaps it's freedom of expression. And that they say there's a law that limits that right. But then the state comes back and says, yes, but we believe that limit is justified in a free and democratic society, and here's why. So to stick with freedom of expression, we know that although we say we have free expression, free speech, even in the United States, the law has to accept limits, libel and slander. The famous Holmes example of falsely crying fire in a burning building. A civilized society has to limit rights. And so even on a libertarian view, you find limitations on rights that go beyond a very strict Benthamite view. I mean, you're not allowed to falsely cry fire in a crowded building. doesn't prevent anybody strictly from doing what they want to do, but it will lead to chaos. It will lead to deaths. It will lead to things that are bad for society. The Americans have to go about this by internal limits on the rights because they don't have our Section 1. We have our Section 1. And so much of the Charter jurisprudence actually turns on Section 1. Is this justified?
Mm. Since we're talking about the United States, we must get to the inevitable question of what's happening with the Supreme Court in the United States. And it's actually rather well put by one of our members on Salt Spring, who says, the United States is deeply divided over the rapid appointment of a new Supreme Court justice. If justices are charged with making decisions based on the law, why is there such celebration on one side and such gloom on the other? I guess he's getting...
is very well put.
It is very well put.
Well, one of the things that has happened in the United States over past decades, particularly the last 5 or 6 decades, is that the Supreme Court has become politicized in a sense that many people associate particular justices with particular social positions on things like abortion, Medicare, whatever, and they associate them with a particular party. And this has led to a situation where parties have a sort of de facto, quote unquote, ownership of a judge they appoint. So the Republican, Mr. Trump and the Senate have appointed 3, and they're always said to be, and they are conservative, and many hundreds more in the lower federal courts, which you don't hear as much about. And they are very happy with this. And Democrats try to do the same when they're in office, although they were much less successful for a variety of factors we can't get into, dealing with relating to majorities, filibusters, and so on. So what's happened in the United States is that the judiciary is politicized in this way, and everybody kind of knows it or thinks it the case. The judges themselves may disavow it. The latest justice was at great pains to say that she would be independent of the party of the president. But nevertheless, her social positions are such that people on that side, as evidenced by her previous decisions, mainly, people are hopeful that she will favor their position. This became a real issue, I believe, after Brown versus Board of Education in the 60s, which was the desegregation decision. And many people resisted that in the United States, resisted it very, very deeply. It did not conform to their view of what the United States society should look like. And so and then at the same time, a little bit later, another 10 years, you got Roe versus Wade, and many people didn't like that. So then people, particularly in the Republican side, said, we've got to start putting in judges who will see the world the way we see it. And this division, which we now see in American society, was there then. It's probably always been there. It's the legacy of slavery and certain other things. And so you have this politicization that has taken place in the last 5 or 6 decades. And it is regrettable. We don't have it in Canada.
Well, I would say regrettable is a very mild word for it. It seems to me that it totally undercuts the nature of a democracy, where we assume, certainly in our country, and we assume in Britain, that there is a rule of law, and the judiciary is there to enforce and to interpret and to guide law, and that this is somehow should be above the divisions of politics. And it sounds, the way you describe it, as if the American judiciary, the Supreme Court and the others, have become somehow hostage to the political process and surely are no longer serving their function in a democracy. Or am I being naive?
No, that is the way most people tend to see it. The Chief Justice Roberts himself is more an institutionalist, and he has sometimes voted with the liberal wing. I know he's very personally concerned to maintain the institutional independence of the court, but the reality is that most Americans see it in different terms, and this is and it leads to delegitimizing the court. A month or so ago, I was reading an article in the New York Times or one of the U.S. publications, and it was an op-ed, and they were saying, well, why do we have a court? Why not just let Congress decide these things? Because, and it was a good question to put, but if the court is simply going to be a shadow of a particular party or president or whatever, particular point of view, then why do you have it? Your court, as you so well put it, should be there to apply the law in an independent and impartial way, because every democracy needs that. Just like a hockey game needs a referee, you've got to have somebody who keeps everything from falling into chaos, and that person should be independent and impartial. Unfortunately, that's under threat in the United States, or is perceived to be under threat.
And it seems to be somewhat under threat elsewhere in the world as well. The independence of the judiciary, the rule of law. We see it in Hungary and Poland just in the news yesterday.
Poland is a good example because they had, I think, a pretty good, after the opening up of Eastern Europe, they instituted a democracy, and they put in courts that, I visited them, that were very much based on a model like Canada or Germany, or that kind of independent court model. And then the current president, over the last 6 or 7 years, has whittled away at the power of those courts, has appointed new judges who see the world the way he sees it. And now we had recently the new court cast in the president's image, saying that you can't have any abortions, even if, in extreme circumstances where there are terrible defects in the fetus. And the women are out on the street marching, saying, but this is what happens when you start fooling around with your courts on political basis. You start appointing judges because of their politics or their social positions, and you end up with that kind of situation, and you end up delegitimizing the courts too.
Fortunately, in my sense of it, we're in a very different position in Canada. I think the average Canadian has great confidence in the Supreme Court, as well as a belief that the court is there to look after them, that the court is somehow an ally for all kinds of people who need to have justice in their lives. So fortunately, is that your sense too, that in fact we're in good shape?
And on the whole, that we don't have a tradition of appointing people for their political views. We have a regional tradition. So, for example, you always have a judge from British Columbia, but not written in the law, but there it is. It's very powerful. But we don't say, generally speaking, one can point to one or two arguable exceptions. But the vast majority of judges' appointments don't have anything to do with whether the person has liberal leanings or conservative leanings or belong to a particular party. And the same is true in England, and the French judiciary in a just different way, and the German judiciary achieves the same thing. And so I think this is the way to go, and I hope we can hang on to that tradition.
This leads to a question from Kathy Page here on Salt Spring. It says, since 2016, there has been some improvement in the diversity of newly appointed judges, especially in regard to women. But some groups, such as Indigenous peoples, are still grossly underrepresented in our judiciary. What needs to be done to correct this, and why is it important to do so?
Yeah. Well, I'll take the second one first. I do believe it's important to have diversity. I think it adds the credibility of the court. If people who are coming before the court can see themselves represented there. When I started practicing law, all the judges were middle-aged, white men. There was just no diversity. And, you know, I did feel like an imposter in that system. And of course, you work with it, and we have a good justice system. So I felt justice was done in most cases, but it's not the way it should be. And people should see. The first push was for women on the court, and now we have 4 of 5. And that is good, because can you imagine all those years, if a woman got to court, she stood there before 9 men, and maybe she thought, where is a feminine perspective on my problem, on my equality problem, or whatever it might be. So I'm glad we've done that. We need to have more diversity in terms of race, and we need definitely to have Indigenous representation on the court. Now, it has taken a while for a variety of reasons. There haven't been a lot of candidates because it wasn't until fairly recently, like 3 or 4 decades ago, that Indigenous people started going to law school in any numbers. And of course, in our system, you choose a person for the court from the top level of the bar, and they're usually pretty senior, and the Supreme Court of Canada is once more removed. So you can't just always find the right person who has the right racial characteristic. But I can tell you that there are some very fine Indigenous lawyers and judges in this country now, and that some of them, I believe, meet the qualifications. Another barrier is bilingualism, because now the government has taken the policy and with justification that justices of the Supreme Court of Canada have to be able to work in both official languages. But we have candidates coming up who meet those qualifications. And I am very hopeful that we will see some of these Indigenous women and men on the court in the fairly near future.
No, that's great. I think we have perhaps time for one more question, which, it says, in May 2015, you created quite a stir when you used the phrase cultural genocide. Can you talk about why you used that phrase and what you meant?
Well, I used the phrase rather naively, thinking that it captured very well what I was trying to talk about, which was how Canada had used policies like outlawing potlatch, outlawing Sundance, taking children and putting them in, Indigenous children, and putting them in residential schools and not allowing them to speak their native languages, making them conform to European-based religious traditions. And that was trying to take their culture away. You can't explain laws like that and policies like that in any other way, but they wanted to take the culture of the Indigenous peoples away from them. They wanted to take, as Sutcliffe, I believe, one of the ministers said, take the Indian out of the Indian. Of course, now we recognize that I think these people were well-meaning for the most part, and this was a big idea in the time in the United States, and Canada bought into it, and honorable people bought into it. But we now recognize that it was misguided. I mean, can you imagine saying to uh, a Jewish person, you're fine, but you just can't be Jewish anymore. You can't have your culture, your religion, or anything else, or a Muslim, or a Christian, or anybody. It's a terrible thing to take away an individual and a group's culture, because you destroy their identity. And what is left? A shell of a human being that doesn't know who they are or what they are, and has no sense of who they are and their purpose. So no sense of pride in what they are. And so we recognize now that those were mistakes. And I was trying to describe that, how we had killed the culture, or tried to kill the culture. And so I used cultural genocide.
Yeah.
People criticized that they took the term genocide and said, well, we never really killed anybody. But I did use the adjective culture. And there are people who say quite a few people died too. A lot of little kids died running from those schools and in the cold of winter. So I certainly wasn't intending to suggest that there were pogroms or anything like that in the sense of wiping people out, although one can find some historical examples that arguably amounted to the same thing, like not providing adequate medical care and so on. But I was trying to get at the idea that early policies wrongly tried to take the culture away, kill the culture.
Actually, I think we should maybe end with one more question that's a little bit more
upbeat.
And there is one other question here that in your from somebody on Salt Spring that who has read your book, that you speak at one point about how important you felt at the Supreme Court to make the court somehow more open, more accessible, more transparent to the general public. Can you talk a little bit about the reasons for that and how you achieved that? That's a little bit more cheerful.
This wasn't just me. I think it started with the previous Chief Justice, Brian Dixon, after the charter. But it's been a continuous process. And when I became Chief Justice, I really made a point of saying, the court belongs to the people. It's there to serve the people. And yet many people don't know much about the court and don't know how it operates. And that kind of lack of knowledge, that presumed secrecy, then can foment suspicion, et cetera, et cetera. So we took the policy we wanted to be open, we wanted to be transparent. Even before I was Chief Justice, the decision was taken about the time I arrived on the court, shortly after, that we would have televised hearings, all of the courts. So Canadians could tune in on CPAC, and we thought nobody would, but actually quite a number do, and see how the court operates. And that was so successful because people could see that it was a fair process. We published statistics of the cases we heard, how many cases we were hearing, what categories every year. We published those statistics, talked about how long it was taking for us to decide. So people could look and say, well, is the court doing better this year than last year, or are they doing worse? We tried in the ways we could to make ourselves accountable. And the court, of course, over the years, developed a practice of giving very extensive reasons, explaining in detail why it was deciding what it was deciding, dissenting judges doing the same for their position. And judges started going out, and I certainly did, giving talks to groups like this one, school groups, going to community events and telling people about what the work the court did and how it did it. And I would go on radio and television on occasion, not all the time, but to explain issues affecting the court or how the court was going about its business. And I think this openness has served us very, very well, and is is one of the reasons that I believe the court is respected by Canadians, generally speaking.
Well, and I think the other reason that the court is respected is to a very large degree because of the work that you have done personally. I mean, 28 years on the Supreme Court, and what you have demonstrated to us this evening, an extraordinary level of commitment and intelligence and passion about it. So on behalf of all of us, I just want to thank you so much for a brilliant career and for joining us this evening. Thank you very much.
Well, thank you for having me. It's a really nice getting to know you. I only wish I could be there to get to know your audience personally, but perhaps on some other occasion.
Absolutely. It's a done deal. Thank you so much.
Great.
Bye-bye.
Thank you and good night.
Thank you.